Let's return to Book 2 of On the Social Contract. Chapter 4 is worth taking a look at, since it reinforces some of the ideas about the general will and the sovereign that we've already seen. Most notably, that the general will is general because it expresses the common interest or good, and that we all are equal in political society because we all become part of the political body under the same conditions. We won't focus on it here, though. Instead, we'll focus on chapters 5 through 7, and we'll look at the sovereign and one of its key powers, at the definition of law, and at the importance of the legislator. Earlier in On the Social Contract, Rousseau claimed that individuals don't have the right to dispose of their own lives. Yet the sovereign, which is the people assembled as a whole to make law, does have the right of life and death. How can this be? Rousseau thinks the question isn't phrased very well when it's put that way. He notes that we all have the right to put our lives at risk in order to preserve them. So, for instance, if we're trapped in a burning building, it's not illogical or irresponsible to jump out a third-floor window if that's our only means of escape. Is it risky to do that? Yes. But in taking the risk, we're seeking to preserve our life, not do ourselves in. Soldiers who fight to protect their fellow citizens provide another example. Yes, they put themselves at risk, but they do so for the purpose of preserving lives, even if the lives they preserve aren't always their own. This is why Rousseau notes, the social treaty has as its purpose the conservation of the contracting parties. Whoever wills the end also wills the means, and these means are inseparable from some risks, even from some losses. Whoever wishes to preserve his life at the expense of others should also give it up for them when necessary. He gives a similar explanation for the acceptability of the death penalty. According to Rousseau, we institute it precisely to preserve life. It's intended as protection. And he says, the death penalty inflicted on criminals can be viewed from more or less the same point of view. It is in order to avoid being the victim of an assassin that a person consents to die were he to become one. According to this treaty, far from disposing of his own life, one thinks only of guaranteeing it, and it cannot be presumed that any of the contracting parties is then planning to get himself hanged. The key point to remember here is that the sovereign's power of life and death exists for the purpose of preserving life, not arbitrarily taking it. Let's turn next to what Rousseau has to say about law. First, law cannot concern a particular person or thing. It must be general because laws are acts of the general will. Second, again because laws are acts of the general will, it is the sovereign who makes laws. And remember, the sovereign is all of us. That leads us to Rousseau's definition of law. He says, when the entire populace enacts a statute concerning the entire populace, it considers only itself. And if in that case a relationship is formed, it is between the entire object seen from one perspective and the entire object seen from another, without any division of the whole. Then the subject matter about which a statute is enacted is general, like the will that enacts it. It is this act that I call a law. Note a couple of things here. Clearly, the legislative or lawmaking assembly, the sovereign body, can't meet all the time, or nothing else will ever get done. So we're sovereign when that assembly is in session and we're making law, and we're subjects at all other times, when we find ourselves obeying the laws we made. Of course, someone will have to enforce the law, because the particular will and the general will don't always coincide for everyone. So there will at times be people who have to be forced to be free, as we discussed earlier. The body charged with enforcing the law is the government. And note here, that means that the sovereign and the government are two distinct things. They are not the same. Finally, let's look at the legislator, as Rousseau describes that role. Literally, the word legislator means lawmaker, but as Rousseau uses the term lawgiver would be more accurate. That is, the legislator is someone who proposes laws to the people. Rousseau gives us Lycurgus and the Roman decemvirs as examples. What's important to note is that legislators have no authority of their own. They can only propose laws to the sovereign. Using the example of the decemvirs, Rousseau notes, the decemvirs themselves never claimed the right to have any law passed on their authority alone. Nothing we propose, they would tell the people, can become law without your consent. Romans, be yourselves the authors of the laws that should bring about your happiness. He who frames the laws, therefore, does not or should not have any legislative right, and the populace itself cannot, even if it wanted to, deprive itself of this incommunicable right, because, according to the fundamental compact, only the general will obligates private individuals, and there can never be any assurance that a private will is in conformity with the general will until it has been submitted to the free vote of the people. Why have a legislator, then? There's actually an important reason. Being able to recognize that a law is good and being able to formulate a good law are two different things. The people, in their sovereign capacity, can recognize a good law when it's presented to them, but they're not likely to be able to formulate a good law on their own. That's a different skill set. Okay? So they are well served by having a wise person who can do that, and then propose the law to them to see whether, in fact, it expresses the general will. Our next set of slides, which will be the final set of slides for Book 2, will take up what Rousseau has to say about the size of the state, and they will focus on chapters 9 and 10.